Hello, this is Matt on the Moon Lambo channel. Here's a headline from FinanceFeeds.com. Top U.S. lawyer looks at Ripple's battle with the SEC. And so going throughout this piece, it was interesting to get another lawyer's take on the situation. I was not familiar with this particular attorney prior to this piece, but it was interesting going through it that a lot of the positions that this individual shares, they're kind of shared with all the attorneys that I come across that are not biased against Ripple and or XRP, and also are not working for the SEC. Because the only people that think that Ripple's screwed and XRP, oh my gosh, it's going to zero, that type of stuff. If they're lawyers, then they're just Bitcoin maximalists or they work for the SEC. That's pretty much the only legal professionals I can find that have extreme positions to the negative for Ripple. The other ones that are not biased don't seem to take quite as harsh a look, even if they think Ripple is going to lose the case, because even losing doesn't mean that XRP is necessarily just going to be worthless and go to zero. It doesn't mean that Ripple can't proceed as a company. Now, I do want to be clear, I don't have a legal background of any kind. Also, I'm not a financial advisor. I don't have a financial background of any kind, so I'm not offering financial advice, and you should not buy or sell anything because of anything that I say or write. I'm just an enthusiast in this space, and I'm happy to talk about these things. I really enjoy talking about this stuff because, frankly, I don't really have any friends or family in my real life that care enough to talk to me about this stuff. So I'm thankful for the XRP community, because otherwise I'd have no outlet. So thank you very much, and I really do appreciate all of the support. But I just want to be clear that I run this channel purely as a hobby. It's really fun, but that is all that it is. So let's go ahead and jump on in here. On Monday, Ripple Labs Inc., Brad Garlinghouse, CEO, Christian Larson, board chairman, and the U.S. Securities and Exchange Commission filed a joint letter with Judge Analiza Torres in the Southern District of New York. While this letter is a general pretrial filing to keep the judge abreast as to what's going on between the parties, it sheds light on their respective mindsets. It also informs us, the captivated audience, of what to expect in the coming months. Now, the biggest takeaway is that the sides are not anywhere near a settlement agreement at this point, says Matt Stankiewicz. I hope I'm saying that right. Matt Stankiewicz. I promised myself I wasn't going to laugh at that name when I was recording. Matt Stankiewicz, managing counsel at the Volkov Log. What the hell kind of name is that? Am I saying that right? Look at this. Stankiewicz? Like, I gotta tell you, to me, that sounds like some sort of slang terminology for a very serious infection. Like, oh man, I got that stanky all up on my leg. It's spreading up to my nether regions. Like, damn, got that stanky. I don't know about you guys, but that's what it sounds like to me. And by the way, this is coming from a guy who calls himself Moon Lambo. All right, I'll try and be an adult for the rest of this. No promises. Mr. Stankywicz's perspective this morning is that the parties note that they do not believe there is a prospect for settlement at this time. Now, this is not too surprising, given the proceedings are still at such an early stage. It was always unlikely that the two would reach a settlement agreement so quickly. I wouldn't expect there to be much movement on settlement talks, at least until each party issues a response to the complaint. At this point, both sides are surely confident in their positions, and Ripple is pushing for rapid discovery schedule in order to bring a swift summary judgment motion. Settlement discussions are unlikely to see much movement until the parties see how the judge responds to these motions. Yeah, so I actually do think that's right. I need to be clear, like the way that I word this. The SEC, I think that they feel strongly that they can, in court, I think that they believe that they would be found to be justified in the fact, just the claim that Ripple sold XRP as an unregistered security. But even though I believe that they do believe that portion of it, I do not believe anything they say having to do with the XRP being actually a security today. If they want to say that, I don't believe that they actually believe it, because they did not request that there be a declaratory judgment that XRP be deemed an actual security. And so a judge cannot deem XRP to be a security if it's not requested. The judge simply cannot, rule on such a thing, make such a determination, if it's not even being requested. And so when the initial claim was brought forward, there was no opportunity for that. And so, yes, the SEC feel strong, and maybe rightly so, that Ripple deserves to be fined this or that. I'm not saying that it is, I'm just that they deserve to be. I'm saying, I just said maybe, But, because look, I don't believe that XRP is a security. I mean, just in case you're new, I'm trying to be super clear. Anybody that's been listening to me for a long time knows my position on this, which is that Ripple's going to be proven to be on the right side of history, even if they end up paying some fines, this or that. But I think that Ripple feels substantially more solid on their position, in particular, the idea that that XRP today is not a security. I think that they're very clear on that, and I think the evidence for that is that so Ripple is requiring that there be some sort of declaratory judgment, and that's not the correct legal term for it. But again, I don't have a legal background. But there's a certain portion towards the end of what Ripple filed. It may have been called affirmative defense, but they stated that they want to have clarity surrounding what XRP is today, and so as a result of that. That we will get it. We will get it. If this is fully adjudicated, assuming there's not some sort of settlement prior, we're going to get full adjudication of this, and that means that the issue has to be addressed because Ripple is demanding it, even though the SEC didn't demand it. And so I do think that it's pretty clear Ripple feels more solid on that point. And who knows internally what they think as to whether or not they think it's likely that they'd ultimately get fined or this or that. I don't think that Ripple would care if they had to pay some sort of fine if they could put this whole thing behind them. So to me, that's not the bigger issue. The bigger issue is whether or not XRP is today's security, and also whether or not Ripple will be allowed to sell their XRP moving forward. That's going to be of paramount importance to them because they'd be cash flow negative without the opportunity to do that at this point in their in the company's life cycle. Anyway, I don't think that'll be the case forever as you build out more corridors, get more customers. But they've been building this whole ecosystem out, RippleNet, very rapidly, with the understanding that they'd be able to persist with this funding mechanism because they've been doing it for the better part of a decade, and there's been no problems, and they've been transparent, including with communication to the SEC. So just consider that. The piece continues. As for the long-term outlook at a settlement, Mr. Stankiewicz says that he won't hold his breath. I'll tell you what, I'm going to hold my breath anytime I'm around somebody that's got the Stankiewicz. Like, that's got to be a smelly infection. Anyway, this is a quote now. In normal circumstances, I think that Ripple would ultimately capitulate and reach a settlement early. Based on these early filings, I believe the SEC has a fairly solid case here and have some established precedent following a ruling in their favor against Kick Interactive Inc. early in 2000. Let me pause right there before I read the rest of the quote. That's a reasonable assessment. And so, but this is where, and I brought this up before, but this is important to understand. Even if technically the SEC won, and it is deemed so that Ripple's selling of XRP in the past it constituted an investment contract. That is different than stating that XRP today is an investment contract. So even if Ripple technically lost, if there is a path forward for them to continue selling XRP, and if there is if it is found that XRP today is not a security, then it's like, okay, fine. Technically, legally, Ripple lost, but did they in real life lose? I would say that would be a win for them. Even if they had to pay a fine or this or that, I don't think it would matter as long as their business model still intact, this and that. I don't think it would be I don't think it would be so bad. I think it'd be good. It would be a net positive, including for XRP holders. That's my belief here. Here's the rest of his quote now. That said, Ripple has a major interest, and most importantly, the resources, in pushing this case to the very end. A settlement could ultimately prevent the XRP coin from trading within the United States, and Ripple will surely fight tooth and nail to prevent that from happening. Yeah, and so then you're talking about like a horror outcome, effectively, where XRP is deemed to be a security, and in addition to that, it's no longer allowed to be traded. I just think that the SEC is so wrong on the facts on that point. It's just hard to fathom that actually happening. But sometimes bad law passes, so it's possible that would truly be the horror situation. But I'll just tell you this: I'm sleeping easy. We'll see what happens, but I'm feeling just fine. Moving on. The circumstances around this case it says is, they mean the word are a little unique as well, as the outgoing Trump administration, SEC, initially brought the suit. less than a month after the complaint was filed, the Biden administration took over and brought significant turnover to the SEC. Ripple explained in the letter that much of its initial settlement discussions took place with directors that are no longer with the agency. I doubt much progress was made, but regardless, everyone is back at square one now, said Mr. Stankiewicz. And so that's certainly obviously true. That's an idea that I've talked about on this channel before, which is why I kind of agree with what there's another attorney I'm sure many of you are familiar with named Jeremy Hogan. He runs a YouTube channel called Legal Briefs. And he was talking about this idea of, look, if there's going to be a settlement, more likely than not, it's going to come once the new SEC chair is in. And there's not a date set, he's not even approved yet, but maybe it'd be within the coming months, Gary Gensler gets in. This would be a pressing matter. I think this is the biggest case ongoing with the SEC today. And so I think that this would be something that would certainly be on Gary Gensler's radar once he gets in. No way to know exactly what his position is today. We know what he thought about XRP a few years ago, but things have certainly changed. And there might be then an opportunity for settlement, but prior to that, it's always been less likely because you've got basically this acting chair of the SEC and she's jamming stuff up. And then just... I don't think... There's another point made too. Jeremy Hogan, I think it was he that was just talking about this idea of you wouldn't necessarily expect settlement at this point anyway. You'd really want to find out, like what type of ammunition is the other side playing with. This idea that, because look, when you go through the discovery process, just basically learning what legal claims are going to be brought about by both sides and that's shared prior to trial, until you know what they're coming at you with. Like, are you going to settle? You'll be less likely to settle. Doesn't mean you couldn't, but it seems like a settlement would be less likely, which is why, since discovery doesn't end until I think it's August 16th, you really wouldn't expect necessarily to see something along those lines anyway. All right, here's another quote now. Outside of the settlement discussions, the letter also highlights a number of sticking points between the two sides. Most interesting to me is the SEC's push to obtain communications that Ripple considers to be covered by attorney-client privilege. The SEC is looking to obtain any communications and or legal memos prepared by counsel. The SEC notes that these documents and communications are central to the parties' claims and defenses. The SEC has specifically highlighted 2 memos from counsel that review the regulatory status of XRP and apparently warn that Ripple's XRP coin offering could be considered an investment contract. Ripple has understandably balked at these claims, and the SEC notes they will consider a motion to compel, said Mr. Stankiewicz. Let me focus on just one piece in particular I got to talk about here. There were a couple memos. I don't know how these got out. Maybe somebody leaked them. I'm not sure. But the SEC, again, right here, the SEC has specifically highlighted 2 memos from counsel that review the regulatory status of XRP and apparently warn that Ripple's XRP coin offering could be considered an investment contract and thus a security, right? And so that was in some of the earlier days of Ripple. I can't remember if that was 2013 or 14 or what year it was, but it was pretty early on. And so there was a warning, there was a risk that the SEC could come after them for that. But think about what that means. That doesn't mean that that anybody at Ripple actually believed that would have been a reasonable case. They're just saying, hey, somebody could have made this claim. Well, it probably wouldn't be strong, this or that. But hey, just so you're aware, because you got to look at all aspects of the given scenario, given the seriousness of this, is what you're paying a lawyer for, right? But just consider this: like, what if the SEC was going to make the claim that the sky during the day is always purple? And what if you had a lawyer that knew that it was perhaps likely that the SEC would make such a claim? Does that mean that you believe the sky is purple? Or is the SEC making a stupid claim because the damn sky isn't purple? Hashtag idiot sticks, right? So people look at it like, I think a little bit incorrectly, just thinking if you have the idea that just because there's a risk that the SEC could charge you or something, that means that you shouldn't have proceeded in the way that you're proceeding, I think that's incorrect. To me, that doesn't logically follow. The sky is not purple. All right, and so I think there's one final quote here. Here we go. The SEC is currently preparing an amended complaint, which it expects to file by the end of the week. Garlinghouse and Larson noted they are waiting for the amended complaint before their respective responses. We'll continue to monitor this case going forward, he concluded. And so the amended complaint actually did come out. This piece was literally from yesterday. So I don't know why it took him a little bit to get out, but either way, the perspective from Mr. Stankiewicz is appreciated here. I think that he was just, frankly, being quite genuinely honest, because he doesn't appear to have a dog in the fight. Frankly, I think that he was just being rather forthright here, and that's the type of stuff that I appreciate. It just grinds my gears trying to read through like just clearly disingenuous perspectives from Bitcoin maxi trolls. But somebody like this, even where he's saying like, the SEC feels like they have a strong case, like, I can handle all that stuff. They probably do on that point, but on the points that matter, which will be discussed on whether or not XRP today is a security, I'm not convinced that they think that they have a strong case there. And Mr. Stankiewicz here didn't say that either. So there we are. But interesting stuff here. Anytime I find another lawyer that's willing to publicly share their opinion on this, I'm always going to bring that information, because I just want to be as armed with as much information as possible, especially given that I am an XRP holder, and it's undeniably so that the SEC's actions against Ripple, which are almost 100% nonsensical, if not 100%, that's impacting me, and it's impacting every other XRP holder. So I just want to continue to arm myself with knowledge and perspective from people that do have legal background, because I just don't have, I just don't have that type of background. But I will go ahead and wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.